Good afternoon. Calling to order the Tuesday, March 9th, 2010 regular meeting of the Sunshine Ordinance Task Force Compliance Amendments Committee. A roll call, please.
Yes, Member Craven Green.
Here.
Craven Green present. Member Nee.
Here.
Nee present. Member Washburn.
Here.
Washburn present. Member Johnson.
Here.
Johnson present. Member Goldman.
Here.
Goldman present. Madam Chair, we have a quorum.
Thank you. First item.
The first item is the approval of February 9, 2010 meeting minutes.
Member Nee.
I'm just curious to know why they're not included in our packet.
It is my fault, through the chair.
I think you were handed a copy.
Oh, okay.
I don't have a copy.
Here.
Oh,
Madam Chair,
Yes.
question to the Mr. Rustum. Were these included in the electronic version of the agenda?
No, Madam Chair.
Okay. In that case, I'm going to move to continue this to the next meeting.
Second.
I'll move in seconded. Discussion. Is there public comment on the minutes? Seeing none, without objection, this will be moved. This will be continued to our next meeting. But I would also note that one of the issues that was on here is item number 2 should have been continued to this meeting. So please note, Mr. Rustin, that item number 2 should be on next month's compliance and amendments.
Madam Chair, Ms. Babbitt emailed me and asked that her complaint be withdrawn.
Oh, so it's been withdrawn?
Yes, and
Okay.
she is taking. According to the email, she says she's taking her case to the Superior Court.
Okay, all right. So this compliance on this order of determination is no longer needed to be scheduled because she's basically withdrawn her complaint.
That's
Is that
correct. Yes.
Okay, thank you. That would explain why it's not on our agenda. Thank you. So without objection, this will be continued to our next meeting. Next item, please.
The second item is hearing on the status of the January 26 order of determination of Red Star against the City Attorney's Office.
Thank you. And have we heard from Ms. Starr as to whether she would be appearing?
She did not contact me at any time. I did send her the regular notice that went out on Friday. Nothing else.
Okay. And is there a representative here from the City Attorney's Office? Thank you. Is there anyone here just before the City Attorney or the representative from the City Attorney's Office presents? Is there anyone here to present facts and evidence on behalf of the complainant? Seeing none, if you could introduce yourself.
Sure. My name is Jack Song. I'm the one of the public information officers from Office of City Attorney's Office. Earlier before the meeting, we had sent over a letter to the Sunshine Task Force. I just want to make sure if everyone got a copy. If not, okay.
When did you send it?
I believe we sent over at 3 p.m.
At 3 p.m. Yeah, it's
Yeah.
highly unlikely we would have gotten a copy.
That's right. I did bring some hard copies. Give folks some time to take a look at the letter.
Yeah, if we could have a few minutes to look it over.
Thank you.
And if members could just let me know when they've had a chance to review the letter.
I've got it.
Go ahead.
I'm there.
Thank you. Do you have anything to stay on the record in addition to what's in the letter, or would you like to reiterate the points of the letter for us? Or
Sure.
Thank you.
Thank you for the opportunity. I just want to stress that our office did, the City Attorney's Office did properly release 2 employee disciplinary letters to Ms. Brett Starr, and we did properly withheld the investigative report. We believe that our office must follow the law, and these documents were part of the attorney-client privilege and also attorney work product. But I also want to emphasize that we do understand where the Sunshine Task Force perspective is coming from. However, we were not able to release these documents for the above reasons.
Thank you. I am not surprised by the city attorney's position. I think it's to be expected. It's generally the position that county councils and city attorneys have taken with respect to investigations of employee misconduct conducted by the in-house attorneys. I think our point was that given the fact that factual investigations of employee misconduct generally are subject to release, the fact that it's done by a city attorney doesn't necessarily exempt it from disclosure, especially as under our ordinance, the record of any confirmed misconduct of an employee involving personal dishonesty, misappropriation of public funds, resources, or benefits, abuse of authority, is not exempt from disclosure. Now, I mean, the reality is that none of the cases that we cited and none of the cases that the city attorney cites deal with this context. They deal with the issue of what the interface between public records law, and particularly the Sunshine Ordinance, and the attorney-client privilege. The cases that the city attorney has cited in this memorandum are general cases regarding the attorney-client privilege that have arisen in the context of private litigation. So it's not necessarily with respect to the issue A of investigation of employee misconduct, or B by government attorneys. So there really isn't a case on point in this area, and it's an issue that has come up repeatedly for members of the press and members of the public who've sought records regarding allegations of employee misconduct. If there's an attorney anywhere near involved in the process, that's what people hear. We can't release it to you. It's protected by the attorney-client privilege. It's protected by work product. And I think the reason that the task force reached the decision that it did below was because not only are there no cases directly on point, but also our ordinance requires us to go as far as we can in terms of the open interpreting law and inferring that it should require that certain records be open. And given the fact that records regarding confirmed, just as a record of any misconduct, is not exempt from disclosure, is the language of our ordinance. So given that, that's how we made our decision. I'd hoped perhaps that the city attorney's office would look at this memoranda and decide that, the factual information that's collected therein, the stuff that doesn't concern the advice and counsel of the attorney to the department or the recommendation of what the city believes should be done with the employee, that information, high information that really goes to the heart of the attorney-client privilege could be withheld, but that the factual information, here's what the employee was found to have done, or here what the allegations were, should be released. But I see they're not going to do that. So again, I'm not surprised. I think this is an issue that ultimately has to be settled by the Superior Courts. And it is something that is addressed by our amendments. In our amendments, we specifically say that where there's been an investigation into employee misconduct by the city attorney, it should be, or under the auspices of the city attorney's office, it should be released. So we've clarified that in the amendments that are going forward. But in terms of the wider issue on the statewide scale, how this would apply to the city of Palo Alto or another city, that's just going to have to be settled in court, I think. So I'm not really sure what we should do here. Some people might want to think that this should be referred to the Ethics Commission. I personally am of the decision that may not be the best course of action, because I think there's a good faith basis for the city attorney's position. I don't agree with it, but I think it's a good faith basis for doing so. If we thought the Ethics Commission might have a truly independent analysis, it might be worth referring it to them, but I would think on these facts they would decide the same way the city attorney's has. So, so I'm not really sure where to go. I mean, I appreciate that the city attorney provided this detailed response, and I appreciate the city attorney recognizes the steps that we took, and that there aren't any cases on point. We certainly made it clear in order of determination that there weren't cases on point, that this was one of those cases in the intersection between open records laws and the attorney-client privilege that hasn't been addressed by courts. So
I don't know what we can do with it, frankly.
Yeah.
Madam Chair.
yes, Member Nee.
I'm wondering if maybe we should refer this to the California Attorney General's office and seek that office's assistance in interpreting the laws as they apply to this particular case. I'm not sure that the AG would want to get involved, because this is a local matter, and the AG generally doesn't like to get involved in local matters, particularly since this would involve bringing in the Sunshine Ordinance itself as one of the criteria for making any kind of a determination. And I'm not sure the AG would want to do that, want to deal with that. But it might be worth a shot. I wouldn't refer it to any of the other authorities, certainly not to the DA, because it doesn't involve any kind of criminal conduct. As far as the Board of Supervisors, I'm not sure they'd be comfortable making an interpretation. They might look at it from the standpoint of maybe some kind of policy adoption, but I think they would be inclined to take the city attorney's interpretations on it. That's a guess. I think the state attorney general would be the most likely place to refer it, and I'm really not sure they would want to deal with it. That's my take on it.
Right. I mean, I do think that, as I said, this is a very big issue for members of the news media, members of the public, but I'm not sure it generally arises in a local context. So, the Contra Costa Times wants the report done with respect to allegations of racial harassment in the city of Richmond's police department. Right, the city of Richmond says you can't have it because we hired Raymond Marshall of MoFo to do the investigation, and it's attorney-client privilege. Or in our situation, it almost always arises in the context of a local matter, of a local jurisdiction refusing to produce it. So, in terms of an issue of statewide import, I'm not sure they would see it as something that was cognizable as an issue that was within, in a way, their jurisdiction. Is my only concern. I mean, it's an issue that occurs all around the state. That's true, but it's not something that...
Not a state-level case.
Mm-hmm.
Yeah.
It tends not to be a state-level case because it arises in the context of local attorneys, local government attorneys.
I think Member Washburn.
Yeah, I think we have an impasse here regarding, what to do vis-a-vis this matter, but I'm thinking it might be a useful case or talking point for us as we're working to get passage of the amended ordinance. This is an example that we can use for why we need, these amendments.
Right, I would tend to agree with that. Member Nee?
One thing we could do is refer this to the task force without a recommendation, and just see if the task force wants to take it anywhere.
Oh.
That's fine by me. If we want to, what we would do is refer it back to the full task force for their consideration of whether or not we should refer the failure to comply with the order of determination to one of the enforcement bodies that we refer matters to, the Ethics Commission, the Board of Supervisors, the District Attorneys, or the State Attorney General's office, and let them have that discussion. It would pretty much mimic what we were doing here, but there may be people on that body who feel more strongly that it should go forward than we do. So without objection, we'll refer it back to the full task force for their consideration of whether to refer the failure to comply with the order of determination onto another body. If you'd like, you have a couple minutes to address us or make any further points if you wish.
No, I just want to thank you for the opportunity. Obviously, my law is not my background, but I will deliver the message to my colleagues.
Great. Thank you very much. We take public comment on this item. Seeing none, public comment is closed. So without objection, this will be referred back to the task force for their consideration of a potential referral. Thank you. Next item.
Item number 3 is hearing on the status of the January 26 order of determination of Kenneth Kinnard against the Human Rights Commission.
Thank you.
How are you, Madam Chair? How are you?
Good afternoon.
members.
You have 5 minutes to let us know about the status of the compliance with your order of determination.
Yes, I received a letter from the Human Rights Commission several days ago outlining a couple of hundred documents that they felt were responsive to the request that I made that has been outstanding now for 2 years now. Those documents I've seen before. None of those documents respond to the request that I made, which the Human Rights Commission published a statement. We have to go back to that again, where they published a statement stating that P&K, when P&K registered for recertification, the Human Rights Commission found out that P&K no longer operated a commercially useful function, and instead was brokering large jobs on large contracts. P&K has never violated the law in that manner, and as you can see, I sent out a packet to show you that the HRC itself stated that they did not have any documents to. Earlier, they had written a letter stating that they didn't have any documents to respond to that, and they did not have a list of brokerage jobs, nor did they have any information regarding me brokering jobs in that manner. I also sent a letter to the arbitrator requesting that information and requesting that he come forth. And the arbitrator is also position is clear in his findings that during the time of the hearing that was held, that there was no evidence that P&K Trucking ever operated in that manner. And so that would be one of the last places that I think the HRC talked about they wanted to look at. I also sent you a packet with some newspaper articles referring to my business in our earlier struggles in the 1980s, and also some information regarding one individual in the 1980s, Don Hesse, sending out a memo to one of the other members of the HRC regarding some requests I had made and some complaints I had had about the refusal of the HRC to support African American truckers and workers. And in the memo that Mr. Hesse of HRC sent to Frank of HRC, it states, at the top, P.S., my friends at the redevelopment agency are having their days and nights with P&K Trucking. And this is the ill will that we find ourselves in. My company has been completely harassed and blacklisted for the last 20 years by the Human Rights Commission. I'm trying to register to work with the redevelopment agency, and it's someone there that I'm having trouble with, and I don't know who. And they will not allow me any credit or consideration for the fact that even though I can prove the discrimination by the various city agencies, the Muni and the HRC, they are putting together strict compliance with the fact that I have to have a truck, insurance, and everything ready to go, which is a great strain on me right now because I just don't have the money to do that. I have a need to work that is critical now. My son graduates from college and will be attending graduate school after the summer, and so I'm going to have to be able to work and help him through. And right now, the way things stand with the HRC continuing with this libel, the other agencies are picking this up, and it's denying me access to the trade that my family has been in over 60 years. And also it's impacting the other African-American businesses. If you go to the parks, you don't see African-American children playing. I mean, they have only one way out of their predicament, which is to make it as an NFL player or a basketball player, or that's it. And so I'd like to see the task force here refer this to the district attorney would be one way to get this thing cleared up, and to find that the HRC is in non-compliance
Thank you.
producing the documents. Thank you.
Is there anyone here to present facts and evidence for the complainant? Seeing none, the representative from HRC, please approach. Thank you. You have 5 minutes.
Hi. Good afternoon, members of the task force. My name is Melinda Canios. I work for the San Francisco Human Rights Commission. Mr. Kenneth Kennard said that we have not responded, and I would like to respectfully disagree and put forth the evidence that I have with me to confirm that we actually have. So, on February 24th, I sent a letter to Mr. Kennard after having received several documents regarding the information he requested, actually all the documents that he requested, and they are P&K Trucking certification file from 1999, which was 89 pages, P&K Trucking certification file 2002, which is 60 pages, appeal of denial of certification by P&K Trucking, which is 330 pages, and the hearing officer's decision, which is 20 pages. So this note I sent to Mr. Kennard, again, on February 24th. I sent it via fax, email, and USPS. I also CC'd this task force on that email I sent to him, as well as our Executive Director, Teresa Sparks. So in the letter, and I have it for you if you'd like a copy of it, but I said, Dear Mr. Kennard, the following items you requested are available for you to see and or obtain copies of. And I list those items, and I tell him that you may come to 25 Van Nest Avenue, Suite 800, to view the documents, and they're also ready for him to have copies made. He would have to purchase those if he would like those copies made. And for him to contact Jill J. Couch to schedule an appointment or for further information about access to the documents. To date, neither I nor Jill J. has received an email, nor a call, nor a letter responding to our notification that the information was made available. So I would like to go back to Mr. Kennard's original request, and this was dated January 6, 2010. He asked for a number of items, 1 through 12 actually, and these items 1, 2, 3, and 4 that I have with me, actually, I brought them down with me, respond to all of those requests, items numbered 1 through 12. So without having to go through them again, I want to tell you that he requested, well, I can go through them all again.
Is
Number
this, I'm sorry,
one,
I'm going to interrupt. This is from January 2010?
January 6th.
Okay, that's not before us. The request that's before us is the October 26, 2009 request for documents related to the statement made in the HRC commission hearing.
I have that as well.
I understand.
That's
Okay, so I just want to
Okay.
be clear. So you're talking about a new request. Okay.
okay. So I made the information available to him, and he still, as of this date, has not responded to them. So unfortunately, Mr. Kennard believes that HRC erroneously came to a finding, and that finding was also supported by a independent hearing officer. I would also like to say that even though it was against P&K, the decision, HRC and the hearing officer went to great lengths during 2002 and the years after that to accommodate his schedule, his request for continuances, his request for hearings, his request for additional time to prepare his case. The HRC and the hearing officer granted all those continuances. And finally, a date certain was set. And this was accumulation of 2 years from the date that Mr. Kennard initially wanted the appeal. And so I have with me all the information that he's asked for and that he's wanted and that he's continuing to request. And we are waiting for him to respond.
Thank you. The matters with the task force. I think this is the following issue. Mr. Kennard, we cannot look at the decision the HRC made. It's not within our parameters. We can do nothing about that. That simply is something we cannot do. We can also not determine whether or not a statement was defamatory or order them to remove anything from their minutes. That is not within our power. Mr. Kennard, you can be seated. If we have a question, and Ms. Candice, you can be seated as well. If we have questions, we'll ask for you to come up. That is something we cannot do. We have no power to do that, and we will not do that. It's not within our jurisdiction. What we can do is determine whether or not HRC responded to your sunshine request for documents. And the particular request that's before us today was all documents related to a particular statement that was made during a commission hearing. Now, HRC, frankly, didn't respond in an appropriate manner, and I think they recognize that. When you receive an IDR, you're supposed to respond by the close of the next business day, and if it's documents that aren't readily available, you inform the requester that it's going to take you some time to get them. We found HRC failed to comply with the IDR. They admitted that. Hopefully, HRC will do a better job in complying with IDRs in the future. But on the underlying issue, it sounds like they've done what they were supposed to, which is look in all the places documents related to this statement reasonably could be found. So I believe they looked in the certification files, but then they also, it sounds to me like they also went and talked to Mr. Epstein, the hearing officer, to get the files related to the hearing. So I don't believe, while HRC did violate the ordinance by failing to respond to the IDR appropriately, and also perhaps failed to move with appropriate haste to get the documents, they've complied. They've done so. They've done what they can to find the documents that are responsive. And now it's up to you to get copies of the documents or inspect those documents if you wish. But that's all we can do. And that's all the powers that we have. So you will have your chance, Mr. Kennard. Not right now, sir. So I don't think there's anything else that we can do on this issue. I would encourage HRC to consistently try to improve their response to sunshine requests and to keep track of documents that maybe have been produced in response to people who ask for the same documents over and over again, to minimize any future burdens and allow you to respond more promptly. So hopefully that will be done. But from my perspective, HRC has acknowledged that they failed to comply, but they now have complied. They've gathered these documents. You may not like what's in them. You may find that something's missing from them, but they're not required to create documents. They're not required to remove statements that were made at a hearing. The only thing they're required to do, and the only thing we can command them to do, is to produce public records and to search for them and to get them from storage and to have them available for inspection and copying, and they've done that. So I don't see there's any other need to take any further action on this. Other members? Member Johnson?
I just wanted to approach the topic of requesting him to make an appointment to come and review documents. And since there has been perhaps a problem complying, maybe there might be a referral to EOT to maybe pick up some of that. Not necessarily to refer the matter to them, but maybe to have EOT get in contact with HRC.
Well, it sounds to me like HRC's last couple times they've been here, they've increased their familiarity with the requirements of the ordinance, and it seems to me they're going to comply. I wouldn't be inclined to refer it to EOT, but I would encourage HRC, if they want additional training on sunshine, to contact the Education Outreach and Training Committee through Mr. Rustum and arrange for that, because we can definitely provide that to members of the staff. Would that address your concern, or?
Yeah, because my concern was he may not like what was in the compliance, but I'm pretty sure I heard her say that when she tried to contact him, she said for him to contact HRC and make an appointment to review that, and that's
you're allowed to do that. You're allowed to set up reasonable times for inspection of public records.
But it's not required, is it?
It depends on what you want. Okay. So I believe what she said was he could either request copies and pay for them, or he could go and make an appointment to inspect them. So he's given the option. And as long as those options are reasonable, for example, as long as it's, the documents will be here in this location for your review at your convenience for the following 2 weeks. There's nothing wrong with that.
Then I withdraw that concern.
I think there's been allegations that the appointment process has been abused in the past, or that, for example, if I want to go see the budget of a department, I really shouldn't need an appointment to go and see that document. I should be able to go in and ask for that document, which, the clerk of the board or the administrator of that department should have in their drawer. But this is a different situation. This is a gathering of records from different sources, and in that scenario, departments are allowed to, if the person wants to inspect, to reach an agreeable appointment for that inspection. Further comments? Ms. Canios, if you would like, you have 3 minutes, to make any closing remarks that you might have.
Thank you. The only thing I want to point out is that, unfortunately, this has gone on for so long. And unfortunately, Mr. Kennard is feeling very, very victimized by the process of one of Human Rights Commission's main program. Many businesses have thrived under this program, and all the businesses that have thrived have provided a commercial useful function. And unfortunately, in Mr. Kennard's case, the director found that he was not able to provide the services that he wanted to provide to the city, and so did the hearing officer. And I will still be available to provide the information to Mr. Kennard. The documents are still at the office waiting for his response. And I'm happy to get in touch with Chris regarding the training and my other colleagues as well. And I appreciate the time that you're taking to hear this, and we will follow through appropriately.
Thank you. Mr. Kennard, you now have 3 minutes to respond.
Task Force members, Madam
If you could
Chair,
use the microphone, thank you.
This is catastrophe. We will have to continue our struggle. I will file another complaint with you regarding this. Just because a person stands before you and speaks to you in the language that you understand about they've supplied these documents and things like that, that shouldn't stop you from looking at the human tragedy here. My family has been destroyed. We've had 3 deaths in the family due to an outside contractor taking over control of the Human Rights Commission. I mean, this affects us all. This time it was me and it's African American people. Next time it could be another race. It could be another group. And now I have to go to legal action against, I think she stated that Mr. Epstein, she talked to him on record. You guys stated that she did talk to him. Mr. Epstein states on record that there is no evidence on record in this case to support an inference that Mr. Kennard played that role as a broker. This is on record. He also states that when I signed my application, I signed up in 2001, as I always have, as a trucker. I just happened to also be a broker, which means you can call a large number of trucks. HRC held up my application for over a year because of the hatred I talked to you about. And I lost my last truck at the end of that year in 2002, and therefore I wasn't able to certify. Now they continue it. They have other people come in, Miss Canios, the other lady that she mentioned, and they continue the cycle of the hatred, and my family has to suffer. We were the biggest trucking company of all when they came after us. We had 30 pieces of equipment. We had 35 employees. We were better than they were because since my great-great-grandfather was in buckboards in Texas, we've always been in the hauling and carrying our goods to markets. What she said again, to libel me again in public about businesses thriving, is totally false. Most of all of the African-American businesses are out of business now. I will be sending you evidence on this. We're in such a bizarre situation that I have to go out and do all this paperwork to send things out to you, and the HRC is in this situation of continually discriminating against me and my family and other African Americans, and getting other African Americans to do it, as was stated by the Pacific Legal Foundation in a case that's in Sacramento regarding the same subject, that if discrimination occurred against African Americans, it had to be by other minorities and other blacks against African Americans. And this is what's happening. They're able to get other African Americans who have just, they're just not there to discriminate against people like me. And I can have a great effect on the thing. With our knowledge of the business, we can put people back to work.
Thank you, Mr. Kennard.
That's the sad part of it.
Thank you.
I will be filing another complaint.
Thank you.
On the same subject. Thank you.
Any other comments? No. I would just logistics for having someone having documents available for review. The question is, how long will HRC have to have documents available to Kennard? I believe Chris or Jerry could comment on that. I believe the task force has said in the past that approximately having documents, for example, for 2 weeks is reasonable. as long as you notify someone that you have the documents for a certain amount of time, and that if they don't review them by that time, then they're going to be going back to storage or going back on the shelves. So, and it's really a question of reasonableness. If you know that the person who requested the record is in the hospital or is ill, then you would say, all right, we're going to hold them for a month. So it's really about a reasonable standard, but 2 weeks is generally considered reasonable.
Okay, thank you.
Thank you. No, sir, that's just, what is your question, sir?
I would like to have the documents held longer than that because in one of the requests, in the the request regarding West Bay Trucking, I still haven't received all of the documents on that request for West Bay Trucking. So I'd like to have the HRC hold the documents for a little while longer on the West
How
Bay
longer,
Trucking.
Mr. Kennard?
I'm going to need another 30 days on the West Bay Trucking. I want to get the information so we can turn
Another
it,
30 days.
so
Ms.
we can turn it
Canios,
over.
can you hold on to the documents regarding West Bay Trucking for 30 days? Is that possible?
I will have to get them again. West Bay Trucking information was from a year ago.
All right.
So I don't have those.
Well, Mr. Kennard, you're going to have to make a new request to
Yes, I need to turn those over to the district attorney's office.
you need to, all right. Well, then you
And
need to make a new request, sir. So I'm
also-
sorry we can't help you with
Okay,
that. Sorry.
thank you for finding them in violation.
Thank you, sir.
Of that action.
Thank you, sir. So there's no further action on this complaint. We appreciate you both for showing up, and hopefully these matters will be resolved. At least we can hope. All right, next item, please.
Item number 4 is developing recommendations for the proposed electronic document retention policy of the Sunshine Ordinance Task Force.
It was my understanding we were just going to keep this on as a standing item, but I don't believe there's anything new or prescient that we need to discuss. There was some information submitted by Chemo Crossman for the packet regarding the preservation of electronic records and other issues, which we've seen before. This is something that we've addressed before and we've looked at before. Member Nee?
Yeah, just a quick question, Mr. Rustum, through the chair. On page 13, the full pages don't show up on the printed copy, and I'm just wondering if there's a way of reprinting them to move them over to the left or to shrink them so that the entire page appears. Page 13 and 14 as well, at least in the copies that I received here.
Through the chair, I'll try and reprint the pages.
Thank you.
Any other further comment on this item? None. This item is concluded. Next item, please.
Item number 5 is consideration of proposed amendments to Articles 1 through 4 of the Sunshine Ordinance, specifically but not limited to definitions and duties of policy bodies and passive reading bodies, Section 67.3 through 67.4.
Thank you. Chris, now, I believe, Chris, just a matter of housekeeping, you had emailed me yesterday a document, and what is that document, just so I'm clear?
That is the amendments with the updates to Articles 3 and 4.
Okay, and were you able to fix the other ones that I suggested
From
in
1 and
Articles
2,
2?
yes.
So my supplemental corrections that came back to you and
is
said
correct.
certain things still needed to be changed. Those have been changed.
Yes.
And so the document that you've sent was Articles 3 and 4.
Yes.
Okay. And is that list posted up to the website yet, or are you waiting for me to
I'm
look
waiting
at
for
it?
your approval first.
Okay. Well, I will do that on Thursday or Friday and get that back to you. Member Nee?
Yes, I have some comments and questions regarding what we have before us, and I'd like to just kind of run through them. On page 25 in our packet. Line 4, I would delete the words "that is."
Any item within.
This is under
Yeah.
on page 25, line 4, under subparagraph 1. I would delete the words "that is." It would just say any item within the subject matter of the policy body. Further down in subparagraph 3, I'm curious about the use of the word "other" there in line 10. This is the first reference to use of personal intermediaries that I see, and so I'm just wondering why the word "other" should be there. So,
I guess it's because or communications media. Any other use of personal intermediaries or communications media. I mean, it could be other communications media.
But it reads just as well without the other. Any use of
any use of personal
intermediaries or media.
That's fine. I mean, these are just things that have been in here that haven't caused any problem to date, but that's fine.
Okay, so we delete the word "other." Further down in line 24, I would insert the word "any" before "item."
It's there.
It is there.
It's just in. It's the second word.
Or
In
CC.
line 24.
Or any. Any's not stricken through.
Everything else is sticking through, but not any. See that?
Well, in the copy I have here,
Line 24?
line 24. Oh, I see. Okay, I'm sorry. My mistake.
No problem.
Okay.
This is why it's hard to follow.
Page page 26. And I think in section, or maybe it's subsection E, lines 14 and 15, I think this has come up. If we are going to attend, or if members of a policy, if a majority of a policy body is going to attend a meeting of another policy body, shouldn't they be required to instead schedule a joint public meeting? Hasn't that been raised by some people like Terry Frank or Peter Scheer, somebody like that?
I believe Terry Frank did, in response to having this sent to him, raise that concern, that he felt that would be a more appropriate method of handling it, would be to have a joint meeting. But from my perspective, that's just not practical. If the majority of the members of the task force want to go talk to the Board of Supervisors about the budget with respect to funding for the task force in the budget's next week, you're not going to get the Board of Supervisors to have a joint meeting with the task force so that can be done. That's my concern. Now, I recognize there's concerns on the other side. I just think that, if you have a majority of members of a body who wish to attend a meeting, and this is not quite correct, I think, do you have the current version in front of you, Chris?
I know. You want me to go get it?
Could you go get it? Because I think there's some additional language here that we added in to E that's not in this particular version. So we'll be in recess for a few minutes until Chris comes back, I guess. Or I guess it's still taping. We can go on.
Yeah, we don't need it.
Member Washburn?
Well, yeah, I was thinking that I can think of any number of meetings where what we would want to comment on would just be one of the items on the agenda, and then there's all the rest of the agenda are things we're not concerned with. So maybe there could be a clause added to reflect that.
Madam Chair,
Yeah.
I believe that some of EOT's training sessions might also fall into that as they're agendized to some other people's meetings that we've gone to before, and they've put us on the agenda for
Right,
sunshine
exactly.
training.
If two people of EOT go to do training or speak to a committee, bam. I think it's a workable solution. I mean, I recognize Terry Frank's concern that you really want to minimize the opportunities as to which discussions can be held or even conveyed. I mean, it's not just that. The concern would be, I go to the Board of Supervisors meeting and I'd say, Centurion's task force needs more funds because we have all these complaints. Like this complaint that's coming up, that's a real problem, this complaint. And then I'd be conveying my point of view, and then Member Need would come up and say, I agree we need more money. This complaint is a real serious problem. And then Member Goldman would come up and say, I don't think it's a serious problem, but I do think we need more money for other things. And so, I mean, at that point, the members start to meld into conveying their concerns about what's going on with their own jurisdiction. And so I think it's a concern, but as long as it's a public, it's a matter that's specifically noticed before a policy body, that meeting is going to be open, that meeting is going to be recorded. And as long as the people who attend and speak are there to observe or to speak on that, speak publicly on that item, then I would see it as more of a benefit than a detriment. So that's I think what the discussion was. But there is some additional language I think that narrows it, that Chris hopefully is going to find.
Okay. Well, we can come back to that. There are some other things I wanted to raise. On page 27, lines 14 through 18, I'm just curious to know why that's proposed for deletion, or has it been moved, or I don't see any notation that it's been moved, and I'm curious to know why this is proposed for deletion.
Well, we had many meetings on this, Member Name, many. It's been a long time, so maybe.
Well,
that's part of the problem.
I apologize. My memory needs a refresher.
And I have a problem with this whole section. When Chris comes back, I'm going to propose that we basically go back to what it was. I think we should. Any of the changes that we've made, I think, should go back for passive meeting body, because I think it causes more harm than good. I think the former text that we had was a little bit obtuse, but people got used to dealing with it, and people got used to figuring out whether or not they were passive meeting bodies. So I have hesitancy in messing it up, especially because it seems that we have narrowed it a little bit, and I do have concerns about that. We've expanded it by saying any other. We've expanded it by saying that anybody, we've expanded the scope in some ways by saying that any body created by the mayor is a policy body, which I also think should be changed. But we've also then narrowed it. So I just think we've done more harm than good in this section, and I suggest we just go back to what it was.
So unstrike through that.
Unstrike through everything. In all of the changes in the passive meeting body section. Everything that's been added, or everything that's been taken out.
Got that, Chris?
I think we should just go back to what it was, because it's a very complex section. And I don't know how many of you have really sat down and read it and thought about whether the shelter monitoring committee, which is a passive meeting body, whether or not they would still be a passive meeting body under this new definition. And I'm not clear on that answer.
So we are reinstating then.
Everything, Rick. Everything in D and under the definition of passive meeting bodies would be go back to normal. We'd take out all of the changes and suggestions, just go back to what it was, because I just feel like none of us have really thought through it enough, and I'm not comfortable with the language. Except for this one item. What I would say is that for passive meeting bodies, 1A, I would say advisory committees created by the initiative of the policy body, a department head, I would say the policy body, the mayor, or a department head, or deputy department head. To expand that a little bit.
27.
This is on page 27, lines 1 to 2. Okay. So it would read, advisories committee created by the initiative of a member of a policy body, the mayor, comma, a department head, comma, or a deputy department head, Or we could say, or department head, or his or her deputy, I don't know, whatever people would think. Because,
Either way, as long as you're indicating that the deputy is.
I mean, you see my concern? And I'm not even sure if departments have deputies. I just know that we've had situations where departments have come in and said, well, the department head didn't create this group.
Well, then,
But this group was, basically a group that functioned and should have functioned like a passive meeting body. And what we've said is, well, it was created with the authority of the head. And so, therefore, it should be a passive meeting body.
the department had someone operating with their authority. That's what you want to say.
Yeah. Just say it outright.
Yeah.
Like, yeah.
Just
So it would be a department head or someone operating with the department head's authority.
kind of clunky, but it's descriptive.
Member Nee?
Their representative, their proxy, their agent, their.
I need your focus on this one.
Yeah, I am. I'm happy with your suggestion that we add the language or his, her deputy, or a deputy department head. Either way, I'm.
Well, how about or another or
Or another department official.
or someone operating with the department head's authority.
Fine.
Okay. So then, Chris, other than the mayor, what else would be everything that we've suggested to be added or changed would be done away with? And then the other necessary change would be on page 8 on line 2. It would go back to saying created by the initiative of a policy body. We need to strike out mayor because that's the other half of what we just did. So the other additions the other deletions and additions would stay. It would still read any board, commission, committee, or other body created by the initiative of a policy body.
Chair Craven.
And then what we've taken out is 6. Policy body should not include a committee which consists solely of employees of the City and County of San Francisco unless such committee was established by charter or by ordinance or resolution of the Board of Supervisors. I don't know if this has come up. I mean, I guess what the thought is that if there are committees that consist solely of employees, but they were created by resolution of the Board of Supervisors, it's creating something more, either by the Board of Supervisors or through a charter amendment, so by the voters. I mean, those, right? I mean, there's something created by the voters or the Board of Supervisors. I don't know. I mean, this is the other thing that troubled me. I'm like, well, why did we delete that? And is this an issue? Has this been a problem? I haven't heard of it being a problem. Rick?
Well, we perhaps could add a clarificatory phrase. Well, it says, unless such committee was established by charter or by ordinance or resolution of the Board of Supervisors, and we could add the phrase something like, and the committee acts solely on internal matters.
No, this is the policy. This is what should be a policy body.
Then in that case, I would bring the language back.
without change. Member Washburn?
I'll accept change the which to a that. I was also wondering,
All right, so we'll bring that back as well. Again, to avoid doing more harm than good.
Chair Craven, while
Yes.
we're bringing things back, I wanted to double check to make sure that the order of parts C and D, we switch them.
Yeah.
And I would hope that would remain. We're not
Yes.
going to undo
Yeah,
that.
I agree.
Okay.
We're going to have policy body first, and we're going to have passive meeting body second. I agree. Now, the real hard thing is going to be when Chris, once the task force approves the proposals and we want to send them out, the document that we're working with is far too confusing. What's going to happen is we're going to have to do a new manual that just shows one set of strike through and one set of underlines. So
Yeah.
it's going to be fun. But yes, that should stay. Those were my main concerns. So, Member Nee, did you have some more?
Yeah, just a few others. On page 29, line 5, I don't think the numeral 1 in parentheses needs to be there. Further down on
That's correct. That should be stricken.
Further down on lines 18 and 19, I would delete the phrase "at his or her discretion." The word "may" implies discretion, so I don't think the phrase "at his or her discretion" is necessary. And on the next line, line 20, I would change the word "may" to "might," because I think, again, there's a difference there. Finally, on page 30, and again,
Can we leave it as may? I mean,
you can. I just think
I don't have a problem with the first one striking in at his or her discretion as duplicative, or as unnecessary, I should say, not duplicative. But as may be relevant, it's just, I think it reads better.
Okay. Page 30, in lines 1 through 4, I'm just wondering, again, I'm wondering why that's been deleted. Gatherings subject to this subsection include the following: advisory committees or other multi-member bodies created in writing or by the initiative of, or otherwise primarily formed or existing to serve as a non-governmental advisor to a member of a policy body, the mayor,
Duplicative.
the city. Is it?
Well, let's go back and read. Read how we define policy bodies and passive meeting bodies, because this is only doing passive meeting bodies. So go back to new D on pages 6 to 7. Advisory committees or other multi-member bodies. We just say advisory committees. Created in writing or by the initiative of otherwise primarily formed or existing to serve as a non-governmental advisor to a member of a policy body, the mayor, the city administrator, or department head, or any elective officer. What we have here is advisory committees created by the initiative of a member of a policy body, which would include the Board of Supervisors. The mayor, what we don't have is a city administrator or elective officer.
You want to add those in on page 7?
I have no problem adding city administrator, elective officer. And the problem is, let's see, hold on a sec. Yeah, that's fine too. I mean, it's just it's basically just. This is totally duplicative, except for the fact that we didn't have. It's created in writing. or by the initiative of, or otherwise permanently formed, created in writing, or by the initiative of. It doesn't make any sense. Or otherwise primarily formed or existing to serve as a non-governmental advisor. I don't even know what this means. I never even knew what this section meant. It didn't mean anything to me. So I would just say is advisory committees created by the initiative of a member of a policy body, the mayor, city administrator, an elective officer, or a department head, or someone operating with the department head's authority. And then we don't need this.
Okay, I'm fine with that.
And then the last sentence, subsection shall not apply, that's already in 4 of passive meeting bodies.
That's all I have, Madam Chair.
Any other comments on this section? I know we've read it again and again. I just felt that we never really got to grasp what we were doing in the passive meeting body section, and or expanding every body that was made by the Mayor Newsom to be a policy body. I think if it's created by the mayor, it's a passive meeting body. It's going to be required to do the posting, which is new, and it's going to be required to post their agenda. They have one, so I think that's going to accomplish a lot of what would otherwise be required. If we made every body created by the mayor a policy body, I mean, that just is a whole different kettle of fish. So I think this is a tighter, more palatable ordinance suggestion. All right, I would take public comment, but there's no one in the public comment gallery. Any other comments by members? Seeing none, I guess we'll continue this item to our next hearing, even though it may be usurped by what we do with the full task force. There may be some work. If we have the meeting at the full task force before our next meeting of this body, there may be things that we can do to help tie up some loose ends. So we should have this item continued.
Is this agendized at the full task force meeting?
Member Nee, if you could talk about that perhaps?
Well, we could agendize it.
I mean, just in case it comes up.
I'm fine with that, but we do have 2 special task force meetings coming up late this month and early next month.
So that's we're doing it. The point is we're doing it by special meeting.
Yeah. Okay.
But if we want to
Publicly. No. A. Publicly. You spelled publicly wrong. Sorry, Brick.
if the consensus here is to put the amendments on the next task force agenda, I can certainly do so.
I'm just thinking of a placeholder agenda item in case we want to discuss it. If we don't have to use that agenda item, but
Okay.
we've got it. Right?
Okay, that's fine.
Because we can't add it right then, right?
That's fine. Mr. Rustin, we will put, well, do we want to put the entire amendments package or just these items, or?
Entire thing. Just so we have it available.
Well, I think by the time we're doing, if we need it to be available, the chair can put it on.
Okay.
So I mean, I would leave it in Rick's discretion as to whether or not we need to put it on. Maybe that we might need to, for example, say we can't get a special meeting, right?
Yeah.
So if we can't get a special meeting lined up, we may have to do it then.
Yeah.
So I would just say leave it to Rick's good
Well,
discretion.
actually, Mr. Rustin informed me earlier that there will be availability of meeting rooms on March 30th and April 6th. Both of those days are Tuesdays. I would have preferred actually that we get them on Wednesdays, but that's the way the cookie crumbles. The question, I think, is how early we want to meet on March 6th, and I will poll the entire task force on it. On April 6th, the room will be available after 5 o'clock. So we'll have to have the meeting at 5.
What's the other day?
March 30th. March 30th and April 6th. And I got a note from Alan Grossman asking if we could conduct those meetings at 3 p.m. As far as the first meeting, the March 30th meeting, I'll poll the task force and ask for a very quick RSVP, and then I'll get back to Mr. Rustin. We can make the final determination on the starting time for March 30th. April 6th, it's going to be 5 p.m. And if nothing else, having this item as a placeholder at the full task force meeting can kind of perk up their eyes and let them know that it's coming, and then, we all need to review it and be ready at the 2 special meetings to dot all the I's, cross all the T's, etc., and be ready for the next step, which is to start taking it to individual supervisors. Also, there's some other things we'll need to do between now and then, paper-wise, but we need to get ready for that next phase.
I was just wondering about a potential problem with having it as a placeholder for the regular meeting if members of the public come expecting that there will be a discussion and we don't have one.
Right.
That
and then
could
we're
be
gonna
a
have to have
problem.
Public comment. That's why I think that we shouldn't use it as a placeholder, but that, member needs who decides what's on the agenda a week before, if there's a need for it, we'll have it, and then we'll have a hearing.
Okay.
I agree. Member Johnson?
For future questions, when I review this, I guess I should just send them to you, Chris, right?
Right.
'Cause-
If you have questions or comments,
Specifically about like what we did today, 67-4 went back to the original language, except for the few adjustments that we made. So I just need to look through it because there has been some questions addressed to me, so I need to.
good luck. I can't even understand it. What I would say is that in advance of those meetings, what we're going to need, each of us is going to need to do is to look through that. And if we have any other suggestions or things that we've seen, be they topographical or substantive or inquiries, put those in writing and get them to Chris before the meeting so it can go out to the members and the members of the public. So, all right. Next item, administrator's report.
Madam Chair, I have nothing to add to the administrator's report.
Any comments on the administrator's report? Seeing none? Oh, no public, so no public comment. We would take public comment, but there is no public comment. Any announcements, questions, and future agenda items? Member Johnson.
I won't be at the next full task force meeting, but I would like to have a question if we're going to do anything for Member Chu or have that agendized. I think I brought it up before. But
I guess that's to the call of the chair.
let's just put a question out there.
Mr. Rustin, could we prepare some kind of a certificate of appreciation for Member Chu, and we can invite her to the next task force meeting to receive it, and she should let us know if she can attend.
Through the chair, I'll do that.
Get a cake.
Thank you.
Madam Chair, could you reopen item 6, please?
Certainly, I'll reopen item 6, administrator's report. Mr. Eston.
I will be sending out the forms at the end of the week together with the Form 700 so that I can forward the applications to the clerk of the Rules Committee.
So the Form 700s are due when?
April 1st.
April 1st.
All right. And so you'll be forwarding them to us so we can get them done?
Yes. And also the terms are expiring, so we need the applications again.
Yes, so and there'll be applications as well. I won't have to deal with that. All right, thank you. All right, seeing no other, Member Nee.
Just one brief announcement. There's a good chance that Bruce Wolf will be rejoining the task force. The Rules Committee met last week and forwarded his name to the full board, and the full board is expected to vote on that appointment Tuesday, March 16th.
Great. Good news. All right, thank you. With that, we adjourn the meeting. Thank you.